Hey, this is Emmett Jay. Just want to spend a few moments with you and announce my candidacy for clerk, Circuit Court of the City of Richmond. My family's walked this pavement out here, working the streets, organized communities here in Richmond continuously since 1860. So the first question I have for you is, when was the last time that there was a clerk of court, any court in this region, that was from this region? But it's specifically right here in Richmond. Tell me a little bit about the current clerk. You can't. Hasn't walked these streets. It's not the person that lived next door to you growing up or that lived next door to your parents' growing up. In my estimation, there's not enough that can be said about taking steps to assure that at some point or another, we act together to stop this 400-year monopoly of the court systems here. There are others amongst us and that you've grown up with who can operate the court system just fine. I want to share with you a moment about some of the class-related laws that I've helped to work against here in Richmond. I want to take you back to 1948, and a time when the city of Richmond was just deciding to go with the charter system. Amongst the laws that were laid out that could have possibly become Richmond-based laws or enactments was the famous 9.13, the charter provision. Let me explain a little bit about that provision. That provision basically protected the wealthy class and preferred them over the working class. The city of Richmond has two classes of employees. One's called classified and the other's called unclassified. Now, your unclassified employees are the upper echelon. These are the folk that make the hundreds of thousands of dollars. These are the folk who sit in the ivory towers. These are the folk who are the quote-unquote final decision makers for the city of Richmond. Now, down at the other end of the spectrum, you have the peons. You have the classified employees. Now, this particular law that was laid out and set out in the charter allowed, amongst other things, that if the personnel director decided that he wanted these rules to affect the classified service, there were certain things that he had to do to make that a reality and to give them the full force of the law. Amongst those things was, within a certain period of time, within the first tenure of the first Department of Human Resources Director, or Personnel Director as it was called then, he had to first select the provision and refer it up the chain. The next thing he had to do, the legal department had to draft it and put it in such an order so that the city council could review it and see if it was actually applicable, see if it was something that was fit to be a law. The other thing it had to do was sit it for public hearing. Now, these are all things that had to be done before it could even be considered, let alone be used against an employee, a classified employee no less. And then, after due consideration, public hearing, and acting in accordance with what the city charter required, then and only then would council be allowed to vote on it, and if they saw fit, pass it, giving it the force and effect of law, and making it one of the rules for the classified service. But in the case of 9.13, it was never done. No action was ever taken to enact it. No action was ever taken to really give it the full force of the law. But here's the real kicker. 9.13 applied only to classified employees. And what it required was that if they became a candidate, not one, but if they became a candidate for any office voted upon by the citizens of the city of Richmond, then that classified employee had to forfeit their employment with the city. Now let's look at the flip side of that. The flip side of that was that the unclassified, mind you, these are the people who made the most money, they could keep their jobs. So they could both keep their jobs and run for office. Now these are people who are hobnobbing with the cream of the crop. Those who make all of the money, set all the rules for all of us to go by. Well, that's a disparate application of the law. That's unequal protection of the law. But notwithstanding that, the city has used that law against me on 2 occasions to fire me from my position, and on other occasions to simply force me from an election. And they most recently used it against another brother, Clarence Kenny, firing him from his position with the city. Now, I've taken the city to court and to task on numerous occasions about this law. The most recent occurrence, one of the addressings of this particular law came in 2004, and it was an official advisory opinion rendered by the Virginia Attorney General that declared not just the instant version of the law illegal, but all other prior uses and applications of the law illegal. Now the reason being is because the city is a subdivision of the state of Virginia, and the state of Virginia has a verifiable history of discrimination against African Americans. Because of this, as it applies to voting and elections and voting rights, in accordance with the Voting Rights Act of 1965, the state of Virginia is a covered jurisdiction under Section 5 of the Voting Rights Act. And what this means is that any law affecting voting, including 9.13 and all of its subsequent versions, had to be submitted for pre-clearance before they could ever be used. So on the one hand, you have the fact that the city itself never enacted the law in accordance with the provisions laid out in the 1948 charter. On the other hand, you have this consequence, the consequence that they never did submit it for pre-clearance. Pre-clearance is a mandatory action, one which requires that the law be sent up to a 3-judge panel which sits in Washington, D.C., or that it is sent to the United States Department of Justice for review and a determination that it is not discriminatory and that it will not result in disparate treatment of African Americans or other minorities. This law has never been done that way. In my most recent search for the law, however, I do not see that it exists now. Hopefully that means that they've repealed it, or that the city has finally decided to abandon its peon versus the wealthy class mentality. This is the kind of mentality that still exists in their court system down there. It's the kind of mentality that says that everyday citizens who come in there don't deserve the protection as afforded by the letter of the United States laws and its Constitution, nor by the laws as written by the Commonwealth of Virginia. You have a chance which doesn't arise very often. You have an opportunity, indeed an obligation, that has touched 400 years. 400 years of monopoly, monarchy, and rule in the court system. On November 8th, you had an opportunity to elect somebody who lived across the street from you, somebody that grew up in the neighborhood with you, somebody that you know about. You don't always agree with, but somebody who you know whose principles won't vary from day to day or moment to moment. Somebody that you know will speak truth to power, and even if that power is a judge. Somebody that you know has been to that court system and has been directly affected by the negative and adverse manners in which they treat everyday citizens that come into the court. You have an opportunity to change that. You have an opportunity to send one of your own to be clerk of the court. I'm going to be calling on you to step up to the plate and do what you know is right. Thank you.